Thank you, Mr. Chairman, members of the committee. Under subsection A of this bill, we'll start at the beginning. If within the course of a farm tenancy, a crop planted by a tenant or land leased by a tenant is damaged by a third party, the third party would be required to do the following. First, notify the landowner of the damage, request written documentation of any existing tenant of the damaged crop or land, including their mailing address and a copy of the land lease. And after receiving that information, they would have to send reimbursement to the landowner and tenant for the damage. Under subsection B of the bill, after receiving a third party's request for that written documentation, the landowner would be required to provide the documentation to the third party. Pursuant to subsection A2, if the tenant notified the third party of the damage, the landowner would not be required to provide a copy of the land lease agreement between the landowner and that tenant. I think the reasoning there being that the third party would be aware of the tenant's existence because that was the person who reached out to the third party. Under subsection C, if the tenant contacts the third party concerning the damage and discovers that the third party has reimbursed the landowner contrary to the provisions of the land lease agreement, the third party would be required to send reimbursement to the tenant in accordance with the land lease agreement. This bill will become effective upon publication in the statute book. With that, I'd be happy to take any preliminary questions.
Questions, Mr. Hamilton. Representative Blex.
Thank you, Mr. Chair. Thank you, Mr. Hamilton. I see nowhere in this bill that there's any kind of a penalty phase or a dollar amount or a reimbursement dollar amount for anything. Am I reading that wrong, or is it somewhere?
That issue might be something that would be within the contract or land lease itself, but you are correct that this bill does not expressly spell out possible damages or penalties.
A follow-up, Mr. Chair. That being the case, and I guess, and I understand where we're trying to go with this, but it looks like, you know, we got an open-ended situation, and I, as a landowner or a tenant, would have very limited resources other than maybe a civil action and then have to prove all the damages and all that, and that cost would be on me. It seems to be pretty loosely written in terms of, you know, having any reason for me to collect damages.
It would be somewhat similar to current requirements to enforce contractual obligations, with violating a statute being sort of a de facto admittance of guilt.
More, Representative Blex.
Thank you for enduring me, Mr. Chair. A third party would be, and assuming we certainly have a landowner, we have a tenant that has a lease, we potentially have an oil company that has a lease, we potentially have an electric company that has an easement and a right-of-way, and certainly anything, I understand fully the surface damage to crops that we have, but I guess it looks like to me we could potentially have 4 or 5 leases or easements or third parties that could potentially damage that. And I guess the way I'm reading this bill, they'd have to sort out the landowner and the tenant would be getting whatever check or whatever damage it would be. Am I correct in thinking that from whomever may do it?
Under the provisions of the bill, it essentially creates a mechanism to create notice and awareness of that damage to ensure that the landowner knows that the land or crop has been damaged by some third party, and ensuring that whatever damages need to be collected from the third party are done so in accordance with the existing land lease.
Okay, thank you for that. Thank you, Mr. Chair.
Representative Minix.
Thank you, Mr. Chair. Damage to crops could be fireworks sets off a fire in someone's field. their cows get out or their goats get out and eat the crop, or you overspray with herbicide. Are those types of crop damage?
I believe so, yes.
So this is kind of a wide encompassing deal, and it just sets up a mechanism to notify, and there's no penalties?
Correct. Inside this bill's language, there's no express language concerning penalties for violation, but it creates a mechanism to alert the landowner of that damage caused to the land that's being leased to the tenant.
What's the consequences if someone causes damage to a crop and then does not report it to the landlord or to the landowner?
Be a pretty strong argument in court that that third party violated the requirements of this statute, and they would be possibly subject to civil penalties issued by a district attorney.
Okay, thank you.
Other questions? Seeing none, thank you. Heather, quick fiscal note report.
Thank you, Mr. Chair. The fiscal note on House Bill 2651 states the Kansas Association of Counties states enactment of the bill could result in increased costs for registers of deeds, and there's no state fiscal effect.
Okay, very good. Questions? Seeing none, okay, we will go open testimony. Proponent, Representative Troy Waymaster, chairman of, this is kind of your domain, so we're kind of on your turf. So welcome to this committee.
All right. Thank you, Chairman Rogers. And actually, it's good to be in front of the Agriculture Committee because I served on the Agriculture Committee for many years. And I do miss it because agriculture is a big part of my life. Hence the reason as to why I drafted this bill. And the reason why I drafted this bill, and you have my written comments in front of you, so I'm not going to basically read those off to you. But the reason why is because there's a situation going on where it's not necessarily, and I'll go back to the representative's question in regards to the openness of who could be found in harm's way of actually damaging the crops for a tenant farmer and for the landowner. It's not to be so broad as to fireworks or herbicide, or if the cows get out and they happen to mess up the crop. This is actually for companies that are going out onto the cropland where there is an existing or growing crop, and they're doing, and I'm not singling out the oil and gas industry, which I believe on the back page of the text under item number 2, it does say the oil and gas industry, but that's not exactly who I was wanting to pin this at. But I'll give an example. So my father is a tenant farmer, and I work for my father when I'm not in session. And we have land that was a 95-acre milo field. And we had a company go out there, and it was a 95, like I mentioned, 95-acre field. And they basically went from one corner to the other and damaged the milo crop all the way across the field. When they did the reimbursement, and having talked to my father, they still only reimbursed the landowner. But my father's share in that contract was 2/3 of the crop. But he got no reimbursement back for that. Even though he did all the work, he did the tillage, we did the spraying, and we did the planting, he got no reimbursement for losing that crop. And when you have that swath of a 95-acre field from corner to corner, because they were doing carbon injection wells and seeing whether or not the land underneath or the soil underneath was prudent enough to have a carbon injection well, he got no reimbursement. So what this bill does is it makes sure that the tenant farmer is reimbursed for any crops that they have done the hard work and for the revenue that they would have received had those crops not been damaged. And it just makes sure that the companies are doing their due diligence in regards to making sure that not only is the landowner reimbursed, but also the tenant farmer according to the contract that they have with the farm lease agreement. The other issue that was brought up, and actually I was kind of surprised a question wasn't asked about this, about cash rent. You could have a company who is looking at an entity that owns land, but they actually do cash rent with the tenant farmer, and if that company just gives the check to the actual landowner, according to the terms of the cash rent agreement, everything is supposed to go to the tenant farmer. Well, this would rectify that as well, because there'll be situations where they just try to find the landowner and then they think it's done. In regards to your question, Representative, in regards to penalties, There is actually a penalty built into this. It's on the first page at the very bottom, and that says if the company does not do their due diligence in finding out exactly what the land lease agreement is, and they give the land owner the reimbursement, and then later on they are supplied with the contract and contacted by the landowner and the tenant farmer, then they have to give basically the contractual amount to the tenant farmer. So let's say, for example, they gave the landowner a check for $800 for the damaged crops without checking to see what the land lease agreement was. Then they have to turn around and give the tenant farmer, if it was a 2/3, 1/3 share crop, they'd have to turn around and give the tenant farmer $1,600 because that would be the proportionate amount that they would have to give. So if they would have done their due diligence, it would have been a lot less. But this is falling on the company to do their due diligence and find out exactly what the land lease agreement is. So the tenant farmer, the one who actually receives most of it, most contractual agreements, most of the crop, and does all the work on the land, is not left high and dry if there is damage to the crops. So with that, Mr. Chairman, I'll stand for any questions.
Any questions for Representative Waymaster?
Thank you, Mr. Chair.
Sorry, mic was not on. Go ahead.
Thank you, Troy. Why do we need legislation for this? Why would this not be a civil remedy in court?
Well, because the reimbursement that you would probably receive from a company would be far less than it would cost to get an attorney, go to court, and try to fight this. So this is, I mean, and the reason why is because companies do this all the time. I can give you another example where it's actually land that we own by the Russell-Barton County line. We have no crops on it, but they're redoing the rural water district line, and they're going to damage our land by going across that. And they were completely unaware that they had to pay for any damages on land. And so there are entities out there that either take advantage of the situation or don't know about the situation. But usually the amount of money that you would receive in the damaged crops is going to be, it's not conducive to go to court.
Other questions? Representative Fairchild.
Thank you, Mr. Chairman. In regards to the enforcement provision, as you noted, it does say the third party shall send reimbursement to the tenant in accordance with the land lease agreement. But, you know, what if they just don't actually do this? I mean, what if they just choose to violate that provision? I mean, there's no specific penalties in here that I see if they just choose to not follow the provisions of the law.
Well, as I mentioned before, because of the previous comment that was made when Kyle was giving the basically the description of the bill, it actually says in section 1, item number C, that if they do happen to provide the landowner with just the repayment of the damaged crops, and the tenant farmer finds out, and then they supply that information to the third party, the penalty is that they have to reimburse the tenant farmer in conjunction with the contract. So that's when I gave the example of they gave an $800 check to the landowner without doing their due diligence and finding out what the contract actually means for the land lease agreement. And so then they would have to cut a check to the tenant farmer for $1,600. It would have been much better in their eyes to have done their due diligence and finding out exactly if there was a tenant farmer and a contract lease land lease agreement.
And they would just have to basically file a lawsuit if they just didn't go along with if they didn't go along with the contract, the tenant would basically just have to file a lawsuit in court in order to enforce it.
That'd be the next, but if this was in statute, they wouldn't have to file a lawsuit because they'd be protected.
Okay. Representative Blex.
Thank you, Mr. Chair. Thank you, Troy, and I can sympathize. I had this very same thing happen to me.
I'm sure many have.
Farm a piece of ground that's owned by my brother, and a gas company decided to renew a line, and I had a crop on it, and he got the check. And since he was my brother, I let it pass. But I can understand where you're at. But a lot of leases are oral leases in the state of Kansas, and when you go to FSA, they won't release that information. So in defense of the company, which is I don't necessarily like what they do, but how are they going to be able to find out that information? Because like I say, the bulk of it may be a 2/3, 1/3 oral lease, it may be a written lease, and even if it's a written lease, and the FSA has those splits, they know what the splits are, whether it's cash lease or that. When I go in and tell them this is so-and-so, and they have that, but from my experience, they won't give out that information to a company. And then a second question would be that happened recently, a vehicle, I leased the land, a landowner built a fence, a vehicle goes through and tears up 100 yards of fence, who gets the check for that? And you're leasing it as a farmer. I mean, I can see, and I sympathize exactly where you're going, but I can see a lot of moving parts and complications in this thing that.
Well, I'll answer your second question first. This is in regards to damaged crops, not fencing. So this is specifically on crops. In regards to the first question, believe me, we have a lot of oral contracts with our landowners as well. But you do have documentation either by the FSA office or by the co-op or the elevator on how the crops are supposed to be distributed. Now, there could be language in the bill, which I would probably be agreeable to any type of amendment that doesn't say necessarily contract. Maybe it says the provisions of the agreement between the landowner and the tenant, to where you could just supply the splits and say, this is how the crop is supposed to be divided up after it is harvested. And that would suffice as be saying, there's your 2/3, 1/3 split. So, I mean, we could change the wording from contract. Now, we do have landowners that we do have written contracts with as well. And so maybe it's moving into the age where if you want to have a contract that would stand up in court, it has to be a written contract and not oral.
All right, other questions? Seeing none, thank you.
All right, thank you, Mr. Chairman. Thank you, committee.
Anyone else wishing to testify as a proponent to House Bill 2651? Seeing none, anyone here to testify as a opponent to the bill? Seeing none, anyone here to testify as neutral to the bill? Seeing none, we'll close the hearing on House Bill 2651. Okay. We have one bill left for today. This is kind of deja vu all over again. We're back. A little earlier than last year, but we are. So I will ask that everyone be on their best behavior, that if you hear something you don't like, you can run out in the hallway and scream, or run out the door where it's a few steps out from the north part of the Capitol. You can come back in. This is an issue yet again that I don't believe is quite fully solved. But today is an opportunity for voices to be heard. But I will have decorum in my committee. I'm very agreeable. You will find this is the first time in your committee that I try to give everybody a fair shake and give everybody their voices heard. Whether what side you are on this situation, you will treat conferees with respect. If not, there's this little button down here, and you do not want to be forcibly removed, as I say with a smile on my face. So if we are good to go, let's open up the hearing now on House Bill 2542 and updating certain terms, requirements, and fees for the Kansas Pet Animal Act. So once again, Mr. Hamilton, please explain.
Thank you, Mr. Chairman, members of the committee. Just a brief reminder that yes, last year we did have a hearing on a bill to amend the Pet Animal Act. That was House Bill 2437. We heard that back in March. And you'll see in this new bill for the Pet Animal Act, a lot of amendments are being made in similar areas, but they are substantively different. So we're kind of starting over here with this new bill. So starting at the beginning, Section 1 would amend the definition section of the Kansas Pet Animal Act. The definition of adequate watering would be amended to require, for dogs and cats specifically, a supply of clean, fresh, and potable water supplied in a sanitary manner and continuously available unless the licensee's or permittee's documented program of routine veterinary care specifies a medical reason otherwise, or unless the dog or cat is being transported. For all other animals, adequate watering would mean a supply of clean, fresh, potable water supplied in a sanitary manner and either continuously accessible to each animal or supplied at intervals suitable for the animal species. And then jumping to page 5 of the bill on line 4, a new definition would be added to define resale as a person selling of animals in Kansas previously purchased from another person to consumers or to someone else further down the chain of distribution. Then Section 2, starting on page 5, line 7, would clarify that no person shall operate an animal shelter without a license from the Animal Health Commissioner, except for a licensed veterinarian who operates such shelter from their veterinary premises. Section 3 amends the statute that allows the commissioner to refuse to issue or renew or suspend or revoke a license or permit. New language would be inserted on page 6, starting on line 1, that states nothing in the act shall be construed to prevent any licensee or permittee from operating in such person's private home or residence if such home or residence complies with the requirements of the act. Under current law, the commissioner may not refuse to issue or renew a license or permit or carry out a suspension or revocation unless notice and opportunity for an administrative hearing has been given. There is a current exception in law for this when the commissioner issues a quarantine order on a regulated premises. A new exception would be added to subsection D on page 6, starting in line 33, when the commissioner takes immediate action to protect the public interest under an emergency proceeding. Under law, if a licensee's or permittee's animals have been seized and impounded, but then that person ends up not getting their license or permit denied, suspended, or revoked, the commissioner is required to pay the costs of care and services that were provided to the animals when they had been seized and impounded. This requirement would now be stricken on page 7, line 13. So essentially, if a person was found not to have violated the act, it would not be the commissioner who is required to cover the costs of caring for the animals. Section 4 would amend the requirements for posting bond to prevent disposition of animals seized or impounded and to cover the costs of their care. So language would be added on page 8, line 3, to state that a person's failure to post bond within 10 days after seizure will result in the automatic legal transfer of the animals to the commissioner for transfer, placement, or other disposition of the animal. In no case could the required posting date be extended by any court or other tribunal past the 10 days, regardless of whether the disposition hearing takes place prior to expiration of such 10 days. Additionally, new language would be added to authorize the commissioner to enter into agreements with licensed animal shelters or rescue networks for the purpose of housing and providing care for seized pet animals. The commissioner would be required to reimburse those licensed shelters or rescue network using funds appropriated for such reimbursement. Section 5 of the bill would amend the Act's current civil penalties provisions. This is on page 8, starting in line 40, by stating that when the commissioner imposes an education course on a person, the commissioner may consult with an organization generally accepted by the veterinary community as reputable, as determined by the commissioner, when administrating that educational course. The section would also strike language on page 9, lines 18 and 22, requiring a finding that a person violated the act to require the person to pay costs of care during impoundment. So that change is just made for conformity throughout the act. Section 6 would amend the Act's inspection requirements on page 10, line 16, to add requirements for licensees, except temporary pet shops, who cease their licensed activities, including requiring 10-day notice to the commissioner and a closing inspection. Under current law, the commissioner is required to have training procedures for inspectors. Such requirements would be amended on page 11, line 14, to cover specific additional pet animal care practices. Such procedures would no longer need to be made in consultation with the Kansas State University College of Veterinary Medicine. Section 7 would require additional rules and regulations on page 12, line 8, to cover exercise and socialization, disease prevention, biosecurity, and closing inspections. A current requirement that the commissioner only apply federal rules and regulations to USDA licensees would be stricken on line 20 and replaced with a requirement that the commissioner consider certain issues when adopting rules and regulations. Section 8 on page 13, line 14, would amend the Act's criminal penalty statute to no longer require the commissioner to pay the costs of care when animals are seized from someone who ends up not being convicted of a violation of the Act. Section 9 on page 13, line 16, would amend the license and permit fees section of the Act. Except as otherwise listed in subsection A, fees would be raised from $450 to $600. Additionally, the commissioner would be required on page 15, line 18, to prepare an annual report on the finances of the Animal Facilities Inspection Program and submit the report to the Pet Animal Advisory Board annually. Section 10 would clarify on page 15, line 26, that no person shall operate a board or training kennel without a license, except for a licensed veterinarian who operates such kennel from their veterinary premises. Section 11 would add an additional member to the Pet Animal Advisory Board, and that person would need to be a licensed rescue network manager. Section 12 would state that a licensee or permit holder who is in the process of ceasing business on September 30 may be issued a temporary closing permit. Current law lists that date as July 1st. So finally, House Bill 2542 would become effective upon publication in the statute book. With that, I'd be happy to take any preliminary questions.
All right. Representative Mosier.
Thank you, Mr. Chair. Thank you, Kyle, for all of that. Section 12, what's the reasoning behind changing the date from July 1 to September 30?
I'll defer that question to the department. It
Yes.
might just be to sync up some of their license renewal dates.
Okay, thank you.
Other questions? Seeing none, yeah, easy. Yeah. All right, thank you, Kyle. Oh, Representative Bleck, sorry, thank you.
Thank you, Mr. Chair, and maybe I'm hurrying through. Definition of a training kennel, do we have that in definition? Does that include 1 dog, 5 dogs, or any annual requirements there?
I might have to take a moment, sit down, and circle back to you to see if that's defined anywhere. Training kennel? Yeah, I have to circle back.
Okay, thank you.
Okay. If KDA doesn't have the answer, Kyle, if you find it, let us know in the process, and we'll get that out. No more questions? We'll stand by if we do. Heather, what about fiscal note?
Thank you, Mr. Chair. The Department of Agriculture and the Board of Veterinary Examiners indicate that enactment of the bill would not have a fiscal effect.
Thank you. Anything for Heather? Seeing none, okay, we'll start with proponents. And first up is Mike Beam, Kansas Secretary of Agriculture. Mr. Secretary, welcome back to committee.
Thank you, Mr. Chairman. It's good to be back. Again, I'm Mike Beam, Secretary of the Kansas Department of Agriculture. I would like to point out with me today is the program manager for this program, Dr. Sasha Thomason, and the attorney that supports that program, Nicole Costanza. I also have Assistant Secretary Josh McGinn. So we appreciate you scheduling the hearing. We think a lot of progress has been made since we were here a year ago. And we'll go over some of those items. Of course, Kyle went through a good deal of them. But I always like to add context on any issue. And I think it's important to know that this has been in our statutes. The Pet Animal Act has been in our statutes since 1988. I'm old enough to remember when it was going on. There was a couple years before it was enacted. But I might add that, there's been a lot of changes with the pet industry, with consumers' needs and desires, and a lot of things have changed. There's been a few tweaks to this bill along the way, or this act, and we think it's time to bring a few more after all that we've learned. But I would like to stress that one of the things that's changed is the size and scope of pets and their relationships with homes, the industries that support those. And I must say that probably no state has gained financially more from that change than Kansas. If you take a look at which states export the most pet food, we're number 2. About $1.19 billion of exports from Kansas. And more importantly, the pet food industry in Kansas has estimated about a $5.62 billion annual output, or 4,900 jobs. So when we look at the agricultural sectors in our state, we break it out with 72 sectors. That'd be sorghum farming, corn, beef cattle, all the sectors. The number 5 sector in agriculture in this state is pet food. And when you think about what it takes to make pet food, it takes meat and grains. So we have benefited, and the pet food industry has contributed significantly. And I think that's primarily because consumers have changed their interest in pets. There's 70% of the homes now are supposedly have pets, and they want the best food, the best care. And a lot of things have changed since this bill went into effect in 1988. After last year, our agency started collaborating with the stakeholders. We had several meetings with the Pet Animal Advisory Board, which is a statutory board appointed to advise the agency, Kansas pet professionals, licensees, industry advocates, trying to develop a bill that was much more acceptable and people were excited about than the one last year. So one of the additions to the testimony that came in kind of late is a side-by-side comparison of the bill last year, which was 2437, I believe, and the bill you have before you. And Kyle went through a lot of the difference, the specifics of this bill, but there's about 4 or 5 things that are not considered in this bill that were last year. We removed some of the changes to definitions, removed the language about the commissioners working with shelters. I think it was it was misperceived that shelters might have exact authority to do the seizure, and that wasn't intended, so we took that out and cleaned it up. And made it very clear, that the commissioner can enter into agreements or should enter into agreements with shelter if we do those seizures. And also some language about the relationship between the director of the program and the animal health commissioner. So again, there's, I think, 5 pages that outlines, 1, the provisions of this bill, and 2, some things that are compared to last year's bill and what is not in this bill that was last year. One of the changes is we would like to have a little more authority on those unlicensed facilities that should be licensed. That we're hoping that this will encourage businesses that need to be licensed, that are aware that they need to be licensed but are not. There'd be ability for the agency to cite them for not having the license but doing the business. And so there's also some new language on the closing inspection process. I think as a 2018 legislative post audit was critical of the program not following up from those who had reported that they were closed. So this bill has a provision that if you close, you're to notify our agency, and then we, of course, are required to go back out and confirm that, I think, within 30 days. The adequate water, the language is different from last year. It's a very key part in the definition section, which is section 1, pages 1, bottom of page 1 and top of page 2. That was intended to try to address, I think, most, if not all, the concerns with the language that was in last year. Another provision of this bill, which I think was in last year's bill, we think is very important, is to have some consistencies with those dual license facilities. If your facility is licensed by both the state and USDA, there are some areas that we can't touch, such as dealing with the health or the condition of animals. We have can access the veterinarian care and have documentation that an animal that's sick, injured, or diseased has had treatment. But if it's a USDA licensed facility and a state facility, we can't have that. So we're trying to make some consistency so that they would be the same. Again, we address, I think, in detail the partnership with shelters and rescues when and if we do go into a seizure situation. They're a very valuable partner in helping with that practice. And part of that is made possible with the legislation that legislature passed in 2022, where we actually have a fund in place for the purpose of reimbursing those who help us by taking care of animals when necessary. The record retention policy, we put that back in again. Right now, it's very clunky, the way we're limited to when we can get rid of records. I think it's within 5 years of the last violation, and we're just asking for a complete, be able to purge those records after 5 years. There is a change to the Pet Animal Advisory Board. Again, I think this was put in about the same time the original act. So as I mentioned, a lot of things have changed since the Pet Animal Advisory Board was created in statute. So there is a provision that would add another member to that advisory board. It would add a representative from the rescue networks. So again, I think I'll just stop with that. We think these are very meaningful. We believe, for the most part, that there was a lot of discussion, and we thought quite a bit of buy-in on it. We passed language back and forth, had a lot of discussion, and if there's some things that still need a little bit of tweaked, we'd be glad to work, with the committee to pursue those. But we think we're very close. I've been encouraged by the dialogue. We've had some good discussions, and I think we're there. But I would stop to respond to any questions that you might have at this time.
Okay. Questions for Secretary Beam? Representative Lex, you get the star today.
Thank you, thank you. My brother trains dogs better than I am, and he owes me money because he collected on a damage, so I want to collect it too.
So did you find that definition of a training?
Well, yeah, I did. I finally, revisor set me straight, and I thank him for that.
Thank you.
I guess my question is, as I recall last year when we heard this prior bill, that the message was to all the parties sit down and work this out and come up with a compromise and bring it back this year. And here we are. However, and I see there's some, but however, I'm getting contacts by people that were at the table that are now telling me that this new bill has changed quite a bit, and this isn't what we agreed to that, particularly on some key issues they felt. And I assume you're still open to some change because obviously they feel like they haven't got everything they needed.
Well, yes, I mean, we would want to consider that. I would say about other than the rescue networks, this has been out there for a couple months, and maybe not everybody was in the meetings where this was discussed, but we felt like there's pretty strong consensus on most of this. Not unanimous, or I don't know if we're ever going to get unanimous within the various organizations, but if there's something we want to have some discussion about, we're most willing to do so.
Okay, thank you for that. The word unanimous is not in my vocabulary anymore since I come up here, so I appreciate that. Thank you.
All right. On the Pet Animal Advisory Board, to add another number, was there ever discussion of just looking at the makeup of that? And if it's a numbers game, if we do have more rescue folks involved here in the state, because I know some of the some of the ones that have representation, can those that maybe have a smaller number, professionals and so on, be clustered as one representative as we look at, if it's more like a numbers game based on the number of breeders, based on the number of rescuers, to have that, what they might deem an equal voice at the table? Was that ever part of the discussion, instead of adding just another member to that board?
I'm not sure, because I was not at the meeting where this was discussed. Previous meetings, the conversation was there weren't many rescue networks when this was created, if any. Now there's a large category of them. So anytime, if you go in and try to take one away from another entity, I mean, that's not one I would recommend. So the thought was they probably deserve to have, not unanimous, but they deserve probably to have somebody on the advisory committee. It's not a policy committee. It is an advisory committee.
So could you explain what exactly their role is? You meet with them and then take back their recommendations or what they're hearing and seeing in the field, and then from there work on things like this as far as your policy and or jurisdictional situations. Can you maybe just step through that?
Yeah, there's actually, I think, a specific statutory responsibility, but they advise the program and the agency on the program, how it's going, rules and regulations, any statutes, any problems, any opportunities. I've had conversations with, please don't think about you're there just to represent your specific category. What collectively can we do to make this a program? Is there something the agency can do that would be more responsive or responsible? But I think to have that dialogue and make everybody feel like they're included is we need to include some of this other category.
Okay, very good. Other questions for the Secretary? Representative Gardner.
Thank you, Mr. Chairman. And thank you, Mr. Secretary, for your explanation of this. As I read through this, I still have a considerable number of questions, and I'll just ask one or so here. But, as we start through this, on page 1, where it very clearly puts into statute what adequate watering of a dog involves, and that there has to be a supply of clean, fresh, and potable water supplied in a sanitary manner continuously. And this does not seem to leave any room in there other than if there's been a veterinary care program in place where limiting water is required. But what about our people who train dogs and have training facilities, and, they take their dogs out to work, and, if you read this, they have to take some water with them, and also working dogs that are herding dogs, If they're keeping these for other people and they have more, enough to where they have to have a license, how does this law account for those activities where they don't have a continuous water supply before the dogs?
So I was looking at the language again on transportation. I mean, you could argue that if they're going to the field, that would be transporting. But my limited experience with this, especially on dog training, is that they make sure water's close by. It may be, a stream, it may be a pond, but especially if there's heat out there. So I think that kind of takes care of itself.
Go ahead. Okay. I think another thing that did not appear to be addressed from last time, and I apologize for not having this ready. I marked this morning. Was the requirement, and I don't have the page marked here, but I can find it here in a little bit, where, here it is, okay, page 14, line 20, and it said failure by the owner of a premise, a licensee or permittee, or other designated representative to make a premise available for inspection within 30 minutes of arrival of the inspector or inspector's authorized representative. And, I have dog breeders and owners that they live more than 30 miles from their grocery store, or 30 minutes. And so, having a requirement that they have to be available within 30 minutes seems quite excessive to me. The farm where I grew up, I still take my dad to Emporia once a week to get his groceries. It's 25 miles to get to town. So if the inspector showed up when I was 2 miles down the road, how would I ever be able to get back there in 30 minutes?
So that continues, there's a lot of questions about that. Again, on context, that was put in because when our inspectors were traveling the state, they may be, 200, 300 miles away, and would contact them. Originally, they would let them know they were coming, and then that's now prohibited. So if they show up and nobody's available, then they'd have to come back another day. So the thought was they'd give them a call. There's a couple options. In your license, you can designate other people that can show up that you can call upon to come there. And number two, you can indicate which days, if there's certain days that you want to be available, or maybe there's some days of the week that you're not available, you can designate that also on your license.
Okay, thank you very much.
Other questions for the Secretary? Representative Murphy.
Thank you, Chair. In relation to Representative Gardner, potable water is a definition for human consumption, safe and drinkable and all, and I'm not too sure too many people want to drink out of a dog bowl. And the other mention was of, drinking out of a stream or something. That's not considerable potable water. So I guess we're kind of getting away from whatever maybe.
I don't think I'd want to stop my dog from drinking out of the stream, though.
Well, I wouldn't either.
Yeah.
I guess I'm concerned about the term in the
definition.
bill.
So it's my understanding this definition mirrors very closely USDA's definition for their kennel program.
Okay, very good.
I could stand corrected if it's not, but that's my understanding.
All right. Seeing no other questions, thank you, Mr. Secretary. We'll have you on recall in case we have questions at the end. And we have time. Up next, Terry Humphrey from the Kansas Pet Advocates. Welcome back to committee.
Thank you very much, Chairman Rajas and members of the committee. I appreciate the opportunity to be here today and speak to you about this important bill. I am Terry Humphrey, the Executive Director of the Kansas Pet Advocates, and our testimony is joined today by over 24 coalition partners. Kansas Pet Advocates strongly supports House Bill 2542. This bill results from many hours of meetings between the KDA and stakeholders. Further, the bill is a compromise among most stakeholders. The bill does address adequate water, as the Secretary just reported to you. And yes, I'd just like to emphasize he is correct, which I knew he would be, in that this is also the same definition as the Animal Welfare Act, the USDA standard, and many others. So. The bill addresses, again, not only adequate water, but it also does authorize the Animal Health Commissioner to adopt regulations. It also speaks to closing inspections, as you've heard, and adding a rescue network representative. Because that is Secretary Beam, went over this also well, I'm not going to reemphasize his points. But I do want to speak just briefly to the authorization for regulations. House Bill 2542 permits, permits the Animal Health Commissioner to adopt regulations regarding exercise and socialization, disease prevention, and biosecurity. Several organizations, including the Purdue University School of Veterinary Medicine and the AKC, the American Kennel Club, state that puppy socialization and exercise are imperative during the first 3 months of life. Socialization helps ensure that a puppy is successful in a home environment and is not dangerous or later surrender to a shelter due to behavioral issues. And again, this just allows him, if he chooses, to handle any of these areas if he thinks regulations are necessary. The bill also provides guidelines for the Animal Health Commissioner to consider enacting regulations that include best management practices for the care and well-being of animals, 2, disease prevention, and 3, morbidity and mortality data to the extent that such data is available, and then 4, generally accepted veterinary medical standards. I want to just pause here because during the summer, late summer, we had an opportunity to visit with the Kansas Livestock Association because they had an interest in a few of these points. And while the Kansas Pet Animal Act does not deal with livestock, in fact, it's specifically precluded, we wanted to talk about things regarding, just answer some questions they may have had on pets, dogs particularly, and socialization. Vanessa Akawi, who was the executive director of the Ottawa Humane Society, went with us to explain that this is a very important thing and it's a recognized standard. So I wanted to mention that to you too. And again, none of this requires the Animal Health Commissioner to do anything. This is just, guidelines and so forth. And if they want to adopt some regulations, it's just a part of a framework. So, okay, closing inspections. You may know that, as was mentioned, that the post-audit did suggest that there were closing inspections that were done when someone was ceasing to operate. Again, as the Secretary said, it's a good provision. I want to speak more about the Rescue Network representative. When the rescue networks were added as a distinct licensing category back in the 1990s, a corresponding representative to the Pet Animal Advisory Board was not added at that time. And I think it is indeed because probably at that time there were very few. And today, that's a growing need, and as a result, a growing interest as well. So as of January 2024, there were 51 licensed rescue networks in Kansas, and those are without representation on this advisory board. However, just to compare, there are 6 licensed animal research facilities. They have a representative. There are 8 licensed animal distributors, and of course, they have a representative. While some may consider shelters and rescues to be the same or similar, what is important to stress here today is this: they are very different in their business operation. Shelters have a brick and mortar building that they provide services from and house animals. A rescue network provides and organizes foster families in our communities to house pet animals until a home can be found. And because there just is, and in a lot of rural communities particularly, there are not enough bricks and mortar facilities. I like to say not enough beds in the inn. They really do rely on a rescue network to take that overload and help them out. So it's a very different voice and a very different operation. I would like to also point out to you in my testimony that I have provided for you a chart. It looks like this. And if you take a look at that, it's going to show you what each of these licensing categories are that are licensed under the Act, and the number of licensees that have representatives. So take a look at that. It's very instructive. So I would just like to close by saying we think that the KDA has done a good job in getting stakeholders together on behalf of rescues and shelters through our state and other stakeholders. We hope that you pass this legislation, and I will stand for questions.
Questions, Ms. Humphrey? Representative Blacks, you really are going for the big star today.
I had an extra cup of caffeine today.
All right.
Thank you, Mr. Chair, and thank you for your testimony. I'm seeing the word animal shelter defined in the bill and statute, and you alluded to rescue networks, but I don't really see, and I think I understand what you said, but it's not they're not mentioned in the bill, and I guess why?
Okay, rescue networks are, the definition for what a rescue network manager is defined in regulation. Okay, I'm getting the nod here. I'm not the lawyer, but that's where they're defined. But the statute references the rescue network manager, and there's a fee within the statute. I think I have that right to a fee for the rescue network as a licensee.
So we have a fee for something that will be defined in regulation. Is that correct?
That is correct, but it's also referenced in other areas of the statute.
Okay, thank you for that clarification.
Yes, sure.
Other questions? Seeing none, thank you. We'll retain in case we,
Thank you.
sorry, Representative Gardner. Sorry about that. Go ahead.
Thank you, Mr. Chair. If I'm reading this correctly, the way this is, this proposed law, that if we go to page 12, it directs the commissioner to adopting rules and regulations, including and to consider best management practices, although that isn't specifically defined, but it says best management practices for the care and well-being of animals and disease prevention and so forth. But when you go on to Section 8, it said the KSA 47-17-15 is hereby amended to read as follows, and it goes, any violation or failure to comply with any provision of the Kansas Pet Animal Act or any rule and regulation adopted thereunder shall constitute a Class A non-person misdemeanor, and goes on into B, upon conviction of a person for any violation of the Kansas Pet Animal Act or any rule and regulation adopted thereunder, the court shall order the commissioner to seize and impound any animals in the convicted person's possession. This seems like pretty strong language for, you know, I've worked in the animal health industry and the animal production world all of my life, and I have never seen law this strict with people who own animals. And I wonder if there's some reason that needs to be put in here in such strict regulation of people who own dogs.
First of all, let me just say, when you're referring to Section 8, this is not new language. It's been in the Kansas Pet Animal Act for maybe 33 years. So I think it's just part of an enforcement structure that the agency has relied on for 33 years. And they could certainly speak to how this, you know, existing law has worked, but I'm not the person to probably to comment on that. And again, just when it comes to rules and regulations, there are no, you know, the Animal Health Commissioner, who is a veterinarian, they're going to use their best judgment in terms of, you know, whatever, and seek input from people when it comes to adopting rules and regulations in the future, now and in the future. They've had a practice of doing that, so they're very responsible.
Okay, thank you very much.
Thank you.
The questions? Saying none, all right, thank you.
Thank you.
Up next, Jasmine Kyle from the Southeast Kansas Humane Society. Welcome back to committee.
I'm a little bit shorter, so this has to go down a bit. Hi, guys. Thank you so much for your time today. Mr. Chairman and members of the committee, my name is Jasmine Kyle, the director of the Southeast Kansas Humane Society. I'm speaking today on behalf of our organization and a coalition of animal welfare supporters in Southeast Kansas who stand in support of House Bill 2542. Water is a basic need for all living creatures. Passing this bill would ensure Kansas dogs and cats at licensed pet animal agencies to have continuous access to water. It would no longer be acceptable to put out a single pail of water during the winter, only to have it freeze and leave the animal without any source, nor watching the animal try to drink scalding hot water from a metal pail in the record high Kansas heat, especially what we had last year. These are not acceptable conditions for any living animal, and it is especially heartbreaking knowing that the animal in need at these locations has no control over this resource, as its caretaker is the primary owner and complete control of that resource. Caring for animals is a responsibility. Thus, these pet animal license owners must be held accountable when these life-threatening levels of neglect happen. Another wonderful point of this bill is permitting the commission to regulate exercise, socialization, disease prevention, and biosecurity. It is incredibly important for animals within rescues and breeders to be socialized on a daily basis with the goal of them becoming pets alongside our community members. These bill items have been recommended today by the American Veterinary Medical Association, the American Kennel Club, the Purdue Canine Care Standards. House Bill 2542 provides a direct line of improvement for the safety of Kansas pets. Thankfully, most Kansas pet animal licensees follow these guidelines. However, in the sad instance where animal cruelty is found in correlation to these bill items, the passing would allow action to be taken to protect Kansas dogs and cats. In closing, we ask that you continue to protect the state's canines and felines by passing House Bill 2542. I thank you for your time today, and I'd be more than happy to answer any questions the committee has.
Thank you.
Thank you.
Questions, Ms. Kyle? Seeing none, thank you. Up next, Crystal Swan Blackdeer, the Leavenworth County Humane Society. There you are.
Here I am.
Welcome back to committee.
Well, thank you for your time. Thanks for the hearing, Mr. Chair, and thank you, representatives. I also want to give a public and personal thanks to my colleagues in the pet animal industry. We have worked incredibly hard to get this right, and I appreciate everything that you've done to bring your experience and your knowledge and your expertise to bear on this. I also want to thank the department Secretary Beam, you and your folks have been incredibly open to input and incredibly understanding and patient with all of us. So I really appreciate that, and I want that to be on the record. I did submit written testimony. I won't read through it. I want to clarify a little bit the difference between shelters and rescues. Many of the shelters who are licensed are municipal shelters. They're run by a city. And if those animals don't move somewhere, they're going to be euthanized, adoptable or not. That's where the rescue networks come in. Rescue networks take in these animals and find them homes. A lot of times they'll move throughout the state to be able to find a home instead of facing euthanasia. And I would wager that back in 1988, there were quite a few less rescue networks in operation because the euthanasia rates were incredibly high. So that's one huge difference in a rescue network and a shelter. Most of the rescue networks are not-for-profits, run out of someone's home with a group of foster homes. So they do an incredible service. And it's been my goal ever since I started attending Pet Animal Advisory Board meetings back in, 2010, I think it was? Yeah. To get a seat for rescues, because someone else mentioned that this is not a policy board. The Pet Animal Advisory Board is not a policy board. We don't take a vote and decide on how we feel on things as a group. I mean, we have taken votes in the past to see where different people stand on things, but it's not our goal to have one voice. Every voice is important. Every point of view is important, and that's why the laboratories have a seat at the board. They may only be 6 licensees. It's not about number of votes. It's about getting the representation, about providing the information to the department that they need to do their jobs, that they need to run this license program, and that they need to do the enforcement that's in the statute. So I just think it's incredibly important to have a rescue seat. If that's the only thing that's going to stop this bill, I believe this bill is the one that should go forward. And if the rescue seat has to wait, the rescue seat has to wait. It will eventually happen because common sense and fairness dictate that. So if the committee decides to strike that and to make that an amendment to this bill, I certainly can live with that. The rescue seats won't be represented. I ran a rescue for 10 years, but I now run a shelter. So it's a different perspective. It's a different way of doing business, and it's a different landscape. So I would encourage you to consider it, but I don't think this bill should die because of one line. It's a good bill. Hundreds of hours have gone into working on this, and lots and lots and lots of discussion and compromise and clarification, and I would hate to see it be torpedoed just over a seat on the board. Thank you.
Thank you.
Questions?
Any questions? Seeing none, thank you. We'll
Thank you, sir.
retain just in case. Thank you for being here. Okay, up next, Lawrence Humane Society. Not sure who's speaking. I have 2 names, so
Hi.
state your name and then.
I'm Shannon Wells. I'm the Executive Director of the Lawrence Humane Society. Katie was not able to join us today, but she is our legal counsel. And so the testimony I'm going to read today just is a reflection of where she and I both stand on this bill. So thank you, committee members, chairman. The Lawrence Humane Society serves as the Lawrence Douglas County area shelter by taking in animals that may be ill, injured, or homeless. We serve over 6,000 animals each year from Douglas County and other areas. Our organization nurtures the human-animal bond by providing shelter, care, and advocacy for homeless and abused animals, as well as resources for pets and people in our community. Today, we are testifying as a proponent of House Bill 2542, which amends certain sections of the Kansas Pet Animal Act. We also write today to kindly ask you to consider a minor amendment to the bill that would add licensed animal shelters to the type of licensee exempted from the boarding and training facility license. Many animal shelters across the state of Kansas are following animal sheltering trends and recommendations for reducing animal intake and keeping pets with their families. A program that accomplishes both of these goals is when an animal shelter temporarily houses animals for owners who are in a housing crisis. The precipitous effect of a program like this is remarkable. Animals are not permanently impounded and burdening the overcrowded shelter system. People are getting housed quicker, and families are able to seek temporary shelter, all without having to surrender their pets. Grants for these programs are rapidly evolving alongside the growing need for temporary boarding services. Lawrence Humane has temporarily housed 240 animals for owners in crisis since 2020. Animal shelters also perform temporary boarding services for local domestic violence shelters through current law. They must have a separate boarding license for this practice. For nearly 20 years, Lawrence Humane has facilitated protection of an average of 7 pets annually for survivors of domestic violence through varying means of care. Today, we respectfully request the committee's consideration on amending page 15, section 10 of House Bill 2542 to include exempting animal shelters and pounds from needing an additional boarding license and offer our support for the entirety of the amendments to this bill. Thank you, and I will stand for any questions.
Any questions? Seeing none, thank you.
Thanks.
Appreciate you being here. Okay. Anyone else want to testify orally on this bill? Seeing none, we do have written-only proponents. Justin Brokaw for the Northeast Kansas Animal Welfare Foundation, Amber Bowlby, Kansas Animal Control Association, Christy Fisher, Wichita Animal Action League, Vanessa Cowley, Prairie Paw Animal Shelter, Susan Kaufman, Meow Matchmakers, and Midge Gringstead, Humane Society of the U.S. Again, this is all on our notes for today, committee. I have no one to testify neutral. Anyone here to testify in neutral of this bill? Seeing none. Now we'll go to oral opponents. First up, Taylor Nickel, Kansas Livestock Association. Welcome back to committee.
Thank you, Chairman Rogers and members of the committee. I will try to be as brief as possible. Again, we thank you for allowing us to share our views on House Bill 2542. My name is Taylor Nickel, and I'm here on behalf of the Kansas Livestock Association and our over 57 members across the state involved in the livestock industry. KLA opposes House Bill 2542 because some terminology in the bill that is used to limit production practices against pet animal breeders could easily be translated to the livestock sector. Specifically, we oppose the requirements of the commissioner to implement regulations that includes exercise and socialization requirements and morbidity and mortality data. If this kind of terminology is ingrained in statute, it could have direct implementation. Oh, sorry guys, it's a long day. Now I've lost my spot. It could have direct implications against the livestock sector. We also believe that this kind of terminology and requirements could be used by groups against pet animal breeders to limit their production practices. We've seen similar tactics be used against livestock operations to push initiatives to limit livestock production practices and tools. I want to also note that we realize that the KDA may need modifications to the Pet Animal Act to support the functionality of their program. We don't take a stance on those issues, and if we were to recommend anything, if you're looking at making technical changes to the bill, we would suggest removing and striking the language that I just mentioned, and then KLA would become neutral on the bill. Sorry that was rough, but I'll stand for any questions.
Any questions? All right, seeing none, thank you. Also, we have Tyler Caver from the Kansas Pet Industry Consulting Services.
Yes.
Thanks. Welcome back to committee.
Thank you. Okay. Thank you, Mr. Chairman, and good afternoon, committee members. My name is Tyler Cower. I'm a private consultant to Kansas pet industry licensees, and I've developed that title after being with the Department of Agriculture for about 5 years, holding all those positions within the Animal Facilities Inspection Program, from administrative secretary all the way up to the program manager myself. I now closely work with the Kansas pet professionals regarding legislation, and I serve as their executive secretary. I also privately consult with licensees who wish to perform above the standards of the Kansas Pet Animal Act through my professional consulting business. So I previously spoke to you guys last year on many highlighted concerns on House Bill 2437. This year, I'm approaching you to explain that after that hearing, the Kansas pet professionals, we took lead in organizing, as you've heard, a group of constituents to come together and collaborate on a bill that all of the sides of industry could agree upon, as they've discussed. So this group is made up of shelter representatives, Department of Agriculture leadership, KPP leadership, and some outside experts. And I want to make sure I express a thank you to both the department and the shelter leadership within the state of Kansas, as we all came together and collaborated on this bill together. And I truly, when I say this, I want to say it as a backing to Crystal of, I truly believe that a working relationship has been forming between the industries in which the protection of pet animals and those that are dedicating their lives to those animals in Kansas is forming, and we're getting to that collective goal. So we're getting there. When I say that, I want to say unfortunately, 2542 does not fully represent the language that our group entirely discussed. So with that being said, we would oppose House Bill 2542. It's a great draft to a great future for the program, and we'd want to continue to work on this language and present it to you all in a future legislative session in a more united group, so that way we can all endorse this collectively. So with that being said, we're willing and ready to continue those discussions and continue those and present to you a drafted bill in the future with everybody's endorsement on that. So I want to thank you for your time, and I am happy to stand for questions. Cower. Thank you.
Mike, want any questions? All right, thank you. Okay, any other one wanting to testify as an opponent of this bill? Seeing none, we do have written-only opponents of Mark Patterson from the Calvary Group and Michelle Russell from the Kansas Pet Professionals. Anyone else wishing to testify that we may have missed earlier? Seeing none, we close the hearing on House Bill 2542. Okay, committee, a couple of things. The House Bill 2607 is the pesticide bill. You should have had the comparison chart from the Department of Agriculture on, I guess it's been added to the online testimony on February 1st. So on what is KDA, what is EPA, and so on in that bill. We're scheduled to work that on Thursday. We are looking to final action on 3 bills tomorrow. Poultry bill is, 2608. We will probably hold off another day. There's been some things come to light that working on a possible amendment, so that has come in late here. We're trying to get a couple of parties together on that. So 2608 will be worked to be determined. And so again, so we'll be here on Wednesday and Thursday, and then off Friday, and we'll work on next week's schedule. If we can get our work done on Thursday, if not, probably we will meet Monday because we'll have the FFA officers here. And we may go ahead and work anything else that we have heard this week that we did not get on Thursday. Clear as mud? Good. Anything else for the good of the cause? What's that? We'll do, no, what's tomorrow? Tomorrow's what? What are we doing? Oh, that's right. Well, I just said it.
Yeah.
2543 and 2564. All right. Okay, with that, we will see you tomorrow. We are adjourned.